Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Okay, good morning, everyone. It's 9:30, so we will get started. First of all, I'd like to thank everyone at the TLA for hosting this CPD. Today's CPD is part of a Thursday Tips series. My name is Sophia. I am Communication Counsel at LAWPRO, and I work in the Claims Prevention and Stakeholders Relations Department. I am speaking to you from Toronto, which is also where the offices of LAWPRO and the Toronto Lawyers Association are located. I respectfully acknowledge that Toronto is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many First Nations, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit. As this meeting is virtual, we're not all gathered in the same place, and for many of you, this acknowledgement is not for the traditional territory you are on. If so, we invite you to take some time to learn about and acknowledge the traditional territory and treaty lands you are on. As a resource, please visit the website native-lands.ca to search for a location to find the appropriate territory and acknowledgement under the Resources tab, or contact the Friendship Centre for guidance. I'd like to recognize the long history of the First Nations in Ontario and the Métis and Inuit peoples. We thank First Nations people who lived and live in these lands for sharing them with us in peace. Today, we'll be sharing tips about wills and estates, and we are joined by Tamar Silverbrook, Sandra Monardo, and Karen Aurora. All of these are practicing lawyers in Ontario focusing on wills and estates. Also, will be joining us my colleague, Chris Stenskowicz. He is a senior claims counsel in the claims department. And you'll also see my colleague, Sean Erker, in the chat section. Thank you, Sean. Today's event is divided into four main areas of discussion. Firstly, you'll hear from Chris, who will start off talking a little bit about claims and then joint retainers and discovery of assets and liabilities. Then you will hear from Tamar, who will talk about documentation and file notes. Thereafter, you'll hear from Sandra on capacity concerns, and last but not least, Karen regarding minors and dependents. Our speakers' profiles are in the written material, and you'll find the written material link in our comment section in our chat, and for those who are attending live. And for those who are not attending live or need to find it later on, you can go to practicepro.ca/CPD, and it will be there. So we have a lot of material to cover, and we have an hour and a half, or just less than an hour and a half. So without further ado, I will turn it over to my colleague, Chris.
Thank you, Sophia. Good morning, everyone. What I'd like to start today with is just a brief overview of the common types of claims that we see here at LAWPRO in the wills and estates field, what the causes of those claims are. So when we're breaking down negligence claims against lawyers practicing wills and estates, there are two top causes of claims. The first one is what we call inadequate investigation. What does that mean? Usually this takes the form of the lawyer not asking enough questions of the client, not verifying information that they've been provided, not asking about assets, how they're held, who are the family members, what's the family tree, what's the dynamic, probing issues such as capacity, and the possibility, the presence or lack of undue influence. Is there asking about whether there's an existing estate plan in place, what that estate plan tried to accomplish, what is the client trying to change now? Is there a spouse? Are there existing support obligations? All of those types of issues can a failure to inquire about them can result in a claim, because obviously without some of that information, the kind of advice that you provide to your client and the kind of options that are offered to the client are limited. So those sorts of issues we categorize as inadequate investigation claims. In close second place, we have communication errors. Communication errors are some breakdown in the communication between the lawyer and the client. Often these types of allegations take the form of you never told me XYZ, or had you told me, this, I would have done something else, or the lawyer never explained to the testator, um, again, A, B, C, right? Um, of course, communications, explaining the client's options is critical, but also equally as important is documenting the advice that has been provided to the client, as well as the instructions received from the client. So, in situations where perhaps a fulsome discussion wasn't had, all of the possible options were not explained to the client. Those can lead to these types of claims, which are quite common in wills and estates. Third, we have what we call errors of law. This is usually a failure to, for example, to anticipate tax consequences of an estate plan, or perhaps there are corporate issues, family law impact on the estate plan, those kinds of issues, right? As you know, estate law intersects with so many different areas of law. So it's quite common to, when developing an estate plan, that it's going to involve tax considerations, corporate issues, family law issues, and yeah, it's important to when we're at that juncture to recognize that perhaps outside expertise may be required, right? Expert advice from an accountant or a financial advisor or tax lawyer, whatever the case may be necessary to properly draft an estate plan, and that accounts for some of these other issues and obligations and potential impacts far down the road. Lastly, we have time management claims. These are issues such as, failing to file an election under the Family Law Act within the 6-month deadline, or a delay in the preparation of a will with the, intended testator passing away before the will is prepared. So those sorts of issues are time management issues. So with that brief overview of claims, let me get into inadequate investigation claims and the importance of the getting all of the information that you need from the client, since this is the number one source of claims in wills and estates. It's important to think about this when we're thinking about loss prevention, and when we're setting up our practices in such a way as to minimize the chances of a claim being made. So at its core, this boils down to asking questions, right? And not taking, when a client comes to see us, they're not necessarily, they're in many times, they will not know what information is relevant and what we need to know to advise them properly with respect to all their options and the best way of setting up their estate plan. So it's important to ask questions that the client may not think to volunteer, right? And ask them about the family dynamics, ask them about, if somebody's being excluded, what the reason for that is. Is there a prior estate plan, right? Well, what was the previous estate plan? What was the prior will doing? What is the client trying to do now? Why is the client making these changes? It's important to ask those questions, because if the will that you're preparing is ever challenged down the road, you know, sort of the questions you asked, the inquiries you made will be scrutinized in one way or another, right? Often this takes the form of a request for the production of a lawyer's file. Sometimes when there's estate litigation, the lawyer's evidence is sought, okay? And of course, some of those situations escalate to a negligence action against the lawyer. All that's to say is, and of course, if you ever find yourself in such a situation where the production of your file is sought, or perhaps your evidence is sought in some estate dispute on a will that you prepared, you should report the matter to LAWPRO as soon as possible. and we can assist you with that. Um, so, since a lawyer's work will often be scrutinized when an estate dispute arises, it's important that there's some explanation, right, for a significant change to an estate plan, right? It's important that you're aware of why the client is seeking to change things or seeking to structure their estate plan in the way that they're they're telling you they want to, and that's documented in your file. That will make the estate plan, the will, harder to challenge, and it will, of course, protect you in the event of litigation in the future. Of course, as part of that investigation, it's important um, to test the client's capacity, and I know one of my fellow speakers will be discussing that later today. But that's part of the investigation, right? Asking the client questions to satisfy yourself that they have capacity, that they are free from any undue influence, that you're aware of things that would materially affect the advice you're giving the client, like outstanding support obligations. It's critical to establish what the assets are that the client is dealing with, and keep in mind that the client will sometimes not have an exact understanding of how they own all of their assets, right? They may believe that they own the house, which is the main asset, their main asset, but the house is actually held jointly with someone else, and it will pass outside of their estate. Of course, that information is going to completely upend potentially their estate plan. So it's important to verify that, right? Perhaps obtain a title search with respect to the property where there are shares involved. Sometimes a client will, tell the lawyer that they own these shares, but it later turns out that the shares are held through a holding company, right? And the holding company isn't referred to in the will. So all of those sorts of issues can lead to problems, and it's quite critical to verify exactly how shares are held, obtain statements for bank accounts, investment accounts to confirm whether they're they're held solely by your client, jointly with someone, or whether there's a beneficiary designation, to track all that information down to avoid problems when the client passes away. And of course, it's equally important to document the investigation that you've made, the questions that you've asked. It's equally important. And I think checklists or client intake forms are great tools to employ to complete this process, right? If you have a comprehensive client intake form for the client to complete before they come in to see you, that helps to get you there, where they can identify various assets, and then you can ask further questions about them or ask for statements when you meet with them. Similarly, using a checklist, is can be quite helpful, right? It prompts us to ask specific questions about certain kinds of assets, about past relationships, about other wills. So those are all great ideas to think about employing in your practice to address those issues and minimize the chances of a claim being made. Let me discuss joint retainers a little bit. Of course, these are not uncommon, especially when there's a couple coming in to develop an estate plan together. Of course, we have a duty to avoid conflicts under the rules of professional conduct, and it's important to identify whether there's there's a conflict right at the outset, right? Whether if the parties coming to see you perhaps have, it may be apparent right at the outset that they have contradictory testamentary wishes, right? That they want to do something else, something that may be in conflict with what the other spouse wants to do. So in those situations, obviously, it's going to be, you're not going to be, you don't want to can't act for both parties, right? If their interests are in a conflict with each other, one of them will have to, retain their own counsel. And, sometimes, the most effective way of sidestepping a claim is right at the outset, right? By not accepting a joint retainer, making sure everybody has their own representation. Of course, if that's not apparent at the outset, and you do accept a joint retainer, you should refer to Rule 3.45 of the Rules of Professional Conduct, which provides some guidance from the Law Society about preparing wills on a joint retainer basis. It's important to explain the limitations of a joint retainer to the clients, that the information provided by either of them will not be confidential from the other, that if a conflict does arise, you won't be able to continue acting. And, of course, in addition to having a retainer agreement signed, it's best practice to have an acknowledgement and consent to the joint retainer signed as well, just confirming that you've provided this advice to the clients and made them aware of the potential pitfalls of acting on a joint retainer. When you're acting in a joint retainer, sometimes it's not uncommon for one of the parties to be the primary contact with the lawyer, and which is again not unusual, but you have to be very careful in these situations to make sure that the instructions being provided are actually the intentions of both parties. That one isn't just acting as the mouthpiece for the other, and perhaps are exerting some inappropriate amount of influence on them. So it's important to be careful in those situations to make sure that both of the clients are actually giving you their instructions willingly and that this is what they want to do. So just keep that in mind when you're hearing from one client more than the other, that you do need to make sure that they both understand the will that you're preparing, a power of attorney, whatever the case may be, and that they're both actually on board with what you're preparing. Now, it's also important to warn clients that if one of them wants to change their will later in the future, there are while that communication may be confidential, you'll have to decline the retainer unless one of a number of events happens, like if the parties divorce or one of them has passed away, or the spouse that isn't requesting the change consents to you acting. So it's important to set all this out at the outset, because there are some serious limitations to acting on a joint retainer. Of course, if a conflict develops between the parties during the course of your retainer, it's important to stop acting, make sure that they get independent legal representation. Can cause some serious problems where the conflict arises and the lawyer continues to act despite the conflicting interests of the parties. And lastly, when you're dealing with blended families, of course, sometimes it's a second relationship. The parties may have children from a prior relationship. Maybe they want to give their spouse a life interest in a property, but how they want to dispose of the residue of the estate is different, as maybe they wanted to go to the children from the first relationship. All of those are issues to keep in mind, again, at the maybe initial intake stage, for potential conflicts that may arise, and to flag as perhaps situations where it would be best for clients to have their own legal representation. So with that, let me pass it back on to Sophia. Thank you very much.
Thank you, Chris. Thank you so much. Okay, we will now be hearing from Tamar, who's going to talk about documentation and file notes. Tamar, over to you.
Thanks, Sophia. Hi, everyone. Good morning. I also will jump right in. Please, as they mentioned, include any questions that you may have in the questions tab. It's important to have a process that you follow as a regular part of an estate planning practice. The process draws on an estate planner's expertise and interpersonal skills, and this is particularly highlighted in the first step in estate planning, being information gathering, which in large part is what was just discussed. Regarding interpersonal skills, the information gathering process requires being part detective and part therapist. This sits within an overall context of relying on your legal skills as an estate planner to determine, for example, what information is relevant, what issue spotting needs to occur and be further explored, as well as what are clients' intentions, values, and affairs that may later help inform the advice provided in establishing a comprehensive succession plan. So we'll start by discussing this first step of information gathering, which I know has been highlighted and questionnaires have been discussed briefly. We're going to get more into the substance of them. Prior to taking instructions from a client, comprehensive information gathering will improve the quality of your advice. The way in which I do so changes based on the profile of the client and the referral source. However, the substance of the information received shouldn't differ. Certain information is required to properly advise on an estate plan, which is consistent across files. For example, you want to obtain information about clients' assets, family tree, family dynamics, dependents, and philanthropic intentions. This informs advice you may later provide, and I'll just give a few examples. So in relation to assets, as an example, if a client has shares in a private company, you may want to consider multiple wills. In relation to the family tree that was briefly noted, amongst other details, you'll want to know if there are minors, if there are any support obligations or other obligations, for example, created by a domestic contract, and where beneficiaries reside. As an example of the importance here, consider if a beneficiary is a U.S. person. Depending on their circumstances and the amount they stand to inherit, which information you would be gathering through information gathering, you may be recommending that U.S. advice be sought by the client and/or beneficiary to protect against U.S. estate tax exposure. These are just examples to demonstrate that you can't properly advise clients without the information gathering process. One way to help ensure that you as an estate planner are obtaining all relevant information and are consistent from file to file is to have a thought-out questionnaire. Depending on the client, I may not send the questionnaire directly to the client. However, prior to moving forward in the estate planning process, I would ensure that in general, we have all the information necessary to complete the questionnaire. In addition to the questionnaire, as part of the information gathering process, you'll want to obtain relevant documents. This topic's beyond the scope of this presentation, but I'll give you a couple of examples quickly. You'll want to obtain copies of any contracts that may bind their estates, such as a domestic contract, and you'll also want to obtain copies of previous estate planning documents. Previous documents can help you develop a picture of the client's overarching intentions, including possibly assets and interpersonal relationship information. They also can help you appreciate reasons for revising their estate plan and areas where you may want to do further information gathering. Recently, and I'll share a brief story, a client's old documents provided a gift to their mother. In their current drafting, I received no instructions to provide a gift to that mother. So to information gather, I asked the client how their mother was doing, like a general open-ended question. This opened up the discussion where I discovered that the client no longer intended to provide a legacy for their mother because they felt as though significant support had been provided to her during her lifetime. Well, that raised my spidey sense to a possible dependent support issue. What did the client mean by sufficient support was provided to the mother? And if there was going to be a potential dependent support issue, that would inform the estate planning, as the client would have to appreciate the risk and decide whether to address it in their wills or otherwise. Sometimes clients here decide not to address it and risk the dependent support claim, but at least I've advised them on that. And I'd make a note of that to the file, which we'll get into in a minute. Whether I have a discussion with a client to obtain background information on the phone, in person, or via an emailed questionnaire really depends on the circumstance. If it's a new client, I would want to have a conversation with them via video call or in person. It's really crucial to get to know your client to be successful. For example, appreciating their personality and family dynamics helps to inform the advice that you provide later. By way of example, if they ask you about executor appointments, you can't really provide advice without knowing them, their family, their circumstances very intimately, or not, maybe intimately is the wrong word, but very well. Like therapists, we need to make clients feel immediately comfortable and draw information out of them that they may not feel comfortable sharing with even their close friends. This is particularly difficult to accomplish over the phone with a new client. If I'm working with a repeat client, depending on when their existing estate planning documents were complete and changes in their circumstance, a call may be sufficient. For example, if we recently completed wills and they just want to change some of their legacies, I may correspond with them to determine the revisions and rationale, but other than meeting to sign documents, we may not meet in person or on a video call. The hiccup here is that it then does put extra pressure on the signing meeting to confirm things such as client intentions or instructions, rationale for revisions, and capacity. If there's any inkling of a capacity or undue influence concern, I'll want to meet with the client alone and in person. At a minimum, when they're signing their documents, I would do that. As clients age, I find that more frequently children are on virtual calls with them to help with hearing and with tech. In these circumstances, I'm particularly careful in note-taking. For example, I would make note of clients' remarks or statements that I've made, and I repeat the exercise of obtaining instructions during the signing meeting. For example, I may say, do you remember if we spoke about who you would like your estate to be distributed to on your death? Can you remind me so that I can ensure it matches what we've drafted for you? And I do this because I'll ensure that the client's kids are not there when we're signing. So I just want to make sure that the instructions we were provided initially matches the instructions on the day of signing, and in a circumstance where there's nobody else around or within earshot. Writing down notes in your notes, like I'll write down exact comments, questions, and concerns and statements that the clients have made, because that might later help support a position that they understood what was happening or didn't understand. But either way, I'll try to capture it verbatim. We'll come back to this in a minute. So at some point in the estate planning process, as I've briefly mentioned, I'll want to ensure that I can meet with the client with no one else within earshot, where the client is not taking cues from another person and is not referring to notes or other aids. After an initial call or in-person meeting, depending on the degree to which information gathering occurred, I may follow up with a questionnaire. For example, an initial meeting may focus on discussing topics more generally, such as beneficiaries and overall dispositive intentions, and precise details such as whether the client has registered accounts may not have been discussed. In this type of situation, or where I think it would be helpful for clients or their executors to have all information in one location, written down and organized, such as contact information of accountants, I'll usually send the questionnaire as a follow-up, and I'll call it their homework so that hopefully they do it and find some humor in it, because it is a long document. And then usually it takes several follow-ups to get that homework back. But it helps the executors and it helps me as well, because all information is in one place. After information gathering, I would want to do an analysis and identify client objectives. Generally do this face-to-face, whether virtual or in person. As a result, if this may occur during the information gathering step, that would inform whether the initial phase is face-to-face. This stage is important because it helps you identify missing information or discrepancies. In conjunction with information gathering and throughout the entire estate planning process, note-taking is crucial. The importance of note-taking is relevant from several perspectives. For one, notes help protect you against liability as a solicitor. For example, if you're accused of failing to identify a particular fact or relevant issue, you may have notes on a discussion had with a client that proves the opposite. It may have been a client's own failure to provide complete and accurate information. Notes may help in supporting whether a client had testamentary capacity and was instructing you without undue influence. Notes also can help in the administration of an estate. for example, by identifying clients' intentions and assets. Going back to the importance of interpersonal skills, notes help establish a better client relationship. For example, clients often are impressed by your memory or your institutional knowledge of their family and other circumstance when you're able to jump into discussion, clearly having background knowledge of their matter. This helps them feel important and helps with that trusting relationship. So for example, if a client tells me that their child's getting married in May, I'll make a note of that. And then if we talk after May, I review my notes before the call, and I'm able to ask them about that wedding on our call. And so while it's not crucial to, information gathering, it is crucial to building that client relationship, which is necessary to help them feel comfortable in disclosing information to you, which is crucial to information gathering. So it's all kind of linked, whether directly or indirectly. Notes also help you jump back into a file after potentially turning your mind away from it, whether it's a week, 2, a month, whatever it may be. And if you work as part of a team like we do on at Fasken, notes are crucial because I might be on a call one day and a colleague might be on a call a different day with the same client. And we need to ensure that our knowledge is the exact same on both those calls. So the colleague can open up my notes from the meeting before and be able to jump back in, no problem, having all the details that have been discussed. Like think about if you went to a doctor and you were repeating the same information every single time. You'd be very, very frustrated. So notes help prevent that. A blocker to having good notes is multitasking. And by this, I mean, if you're leading a conversation on a call or in person, it can be difficult at the same time to take comprehensive notes. So I try to block off 5 to 20 minutes following a client call or meeting for me to fill in my notes. For example, during the initial call, we likely discuss clients' children's personalities if they had children. And rather than making notes during the meeting, I may include a keyword to jog my memory and fill in the sentence immediately following the call or within a day afterward. Another blocker to having strong notes is that important information may be stored across different platforms, such as notes in a Word document, saved in the file, emails, and phone messages. There are different ways to address this. At Fasken, we file everything into a client's folder in our document management system. If there's a particularly important note, for example, if a client provides consent to something in an email, I may copy and paste that email thread into a Word document and save it under notes to file. I might, maybe I'll save it as note re consent on X date. So it's more easily searchable than an email when you probably have hundreds of them. With respect to voicemails, I strongly encourage you to confirm in a follow-up email, and I may then specifically save that email as a note to file under notes as opposed to under emails. Regarding best practices for note-taking, I don't think that there's one correct path. I would say that the best practice is to do what works for you to ensure that you have comprehensive notes that are easily searchable by not just you. After client calls or meetings, I try to save notes to file. That note usually is saved as note re client call on X date and contains the following information. At the top, I'll include a date and a list of everyone on the call or in the meeting. If a child is there but not really part of the meeting, I'll still list them as in attendance. And same goes for other advisors. If the, let's say, accountant or financial advisor has 3 people on the call and only one is chatting, I will list all of them. If the meeting is in respect of a certain topic or email chain, my note will start with a sentence saying that the meeting is in regards to such topic or email chain. Sorry about that. If it's an email chain, I probably copy and pasted the chain into the note to file. Sometimes my note is one sentence saying that I spoke with X client on X date. We reviewed the dispositive provisions and the client confirmed that they accurately reflect their intentions. I try to capture questions, or at least a few asked by the client or other statements clients make that indicate their understanding of our discussion. I also try to capture topics that were discussed, even if the note is a quick "we discussed" and then a list of topics. If certain issues are raised and advice is given, I would make note of that. So particularly from a liability protection perspective, I'd want that written down. For example, if an account is held jointly with a child and the client intends for such child to distribute it equally among the client's children on their death, I would definitely make a note of that intention and advice that I have given, whether or not the client follows my advice. I would also mark down whether I think the client will follow it or not. If I know what the client's done, of course, I would include that in the notes as well. If there's any indication of a capacity concern or concern that litigation may ensue in the future, my notes become particularly detailed, particularly in relation to the signing meeting. I may ask an assistant or student to sit in on the meeting to take notes that I then can fill in shortly afterwards. Usually they can act as a second witness, so from a cost perspective, it's not that big of a deal. These notes would likely include the time at which we met, and this could become important later if it's a question of how meds were affecting a client at a certain time. I've had that one before. I'd list again everybody in attendance, the client's nonverbal demeanor, what they're wearing, because if they look more put together, that could be indicative of something. And I'm not necessarily interpreting the information, but I'm making note of it. Potentially, I would note down what was discussed socially prior to diving into the substance of the meeting. For example, did the client say that they just returned from a trip or were preparing to go on a trip? Points relating to testamentary capacity. So if certain assets were discussed and who raised it, did the client raise it or did I raise it? If the client discussed certain beneficiaries or family members, I would also note that down. Like sometimes they'll make a comment like, oh yeah, it's good that we're appointing this person and not this person as executor because of X, Y, and Z. So again, verbatim, I would try to capture that sentence. In addition to notes, your communication with clients is another way to document the estate planning process. Benefits already have been discussed, but again, include protecting yourself from liability. So you may want to send a memo to a client in circumstances where communicating nuanced, complex issues or lengthy discussions of law comes into play. Emails to clients are another way to document discussions. For example, you may have discussed on call or in person that the client has beneficiaries who reside in a foreign jurisdiction. So you would want to mention the advice that you've given in writing. And then lastly, and this will be my last point today, on reporting letters, that's another great opportunity to document notes for the client. In the letter, you would probably include identifying services you were retained for, especially if it's under a limited scope, communicating the work that was complete and steps taken, including the rationale if appropriate. I'd highlight if the client chose not to follow your advice. Yeah, I'll leave out the examples just because of timing, but we can always come back to it if you have questions. Hopefully, if you've discussed certain risks and they still choose not to take your advice, I would put that in the reporting letter. And lastly, you may want to highlight any important dates such as filing deadlines or times at which they should revisit their estate planning. I'll pass it back off. Thank you.
Thank you, Tamara. Thank you so much. We are now going to talk about capacity concerns. I'll turn it over to Sandra.
Good morning, and thank you for inviting me to be part of this panel. I will be discussing capacity concerns in will drafting and what do we mean when we talk about capacity, red flags, and what do you do if you're concerned that your client lacks capacity. Let's start with what do we mean when we talk about capacity? So capacity is task specific. It refers to a person's ability to make a certain decision for a certain task at a certain time. To make a will, then, we look for testamentary capacity. Capacity is a legal test and not a medical one. Testamentary capacity, the test arises out of common law, and the UK decision of Banks and Goodfellow remains a leading authority. and has developed from there in Ontario. So for testamentary capacity, the lawyer must determine whether the testator understands the nature and effect of a will, recollects the nature and extent of the assets he or she is disposing of, understands the extent of what he or she is giving away under the will, remembers the people he or she might expect to benefit, appreciates and understands the nature of the claims that may be made by individuals he or she is excluding, if applicable, and identify those individuals. This would extend to the obligation to provide for his or her financial dependents or individuals that the testator has a duty to support or would ordinarily support. Lastly, the testator is free of any disorder of the mind or delusions that might influence the disposition of his or her assets. Case law has added the testator's ability to understand, recall, or appreciate the information material to formulating a will, the interplay of material information and consequences of testamentary capacity, or testamentary options, the impact of the information material to a will, and the consequences of the provisions of the will. A good practice would be not to limit your investigation to questions about assets and how to dispose of them, but about the family situation, including age, relationships, education, financial status, or any disabilities or support provided that may be relevant to support claims or support entitlements. It is not sufficient that the testator is able to communicate his or her testamentary wishes. Those wishes must be the product of a sound and disposing mind. Regarding the assets, the testator does not need to have an encyclopedic knowledge of their assets and values. As stated by Justice Penny in Gironda and Gironda, it is unnecessary that a competent testator know the precise makeup of her estate to the last digit, and nor is it necessary for the testator to understand the provisions of a will like a lawyer would. However, testamentary capacity requires a person to be capable of understanding the essential elements of making a will, such as property, objects, persons, who would normally benefit, and revocation of prior testamentary dispositions. The testator does not need to be fair, considerate, or kind, and may even act capriciously, provided that the instructions are given freely from a sound mind, memory, and understanding. Even if the above test is met, consideration should be given to suspicious circumstances that could affect the capacity or free will of the testator to the point of being unduly influenced. So as we talk about undue influence and suspicious circumstances. In Scott and Cousins, Justice Cully noted that undue influence is a subtle thing, almost always exercised in secret, and usually provable only by circumstantial evidence. Undue influence requires coercion and not mere persuasion, and the influence overbears the will of the testator, so that in truth, what he does is not his own act. Actions amounting to undue influence can be subtle or overt. In Vogt and Hay, the Supreme Court of Canada stated, a person may well appreciate what he or she is doing, but be doing it as a result of coercion or fraud. The court identified 3 categories of suspicious circumstances. Suspicious circumstances raised by events surrounding the preparation of the will, circumstances that call into question the capacity of the testator, circumstances that suggest that the free will of the testator was overtaken by coercion or fraud. The most important next question would be to when do we test for testamentary capacity? In the decision of Gironda and Gironda, again, Justice Penny set out that the relevant time for determining testamentary capacity is at the time of giving instructions and executing the will or codicil. So we look to, does having a disability such as Alzheimer's or dementia mean the testator does not have capacity? In considering testamentary capacity, factors such as age, intelligence, experience, education, physical disabilities, some mental disabilities, and language barrier cannot be concluded as evidence of incapacity. A diagnosis of cognitive impairments, mental illness, severe alcoholism, or substance abuse is also not necessarily determinative of incapacity. You may know, as Alzheimer's and dementia and other cognitive disabilities vary in severity, and just because someone has such a diagnosis is not presumed to be incapable of making a will. Again, Justice Penny in Gironda and Gironda concluded that isolated memory deficits or cognitive decline do not on their own establish a lack of testamentary capacity. So what will the courts look to if capacity is questioned on a will challenge, which we all wish to avoid? In some recent will challenge decisions, the courts continue to look first to the opinion of the drafting lawyer regarding testamentary capacity and give the lawyer's opinion great weight. As mentioned earlier, the test for capacity is a legal one and not a medical one. In the decision of K and K Sr., the court relied on the drafting lawyer's evidence to uphold the will and found that the testator can still have testamentary capacity, notwithstanding suffering from mild to moderate dementia. The drafting lawyer took detailed notes, followed a checklist for investigation into assets and for testamentary capacity. The court accepted the evidence of the drafting lawyer over the posthumous retroactive capacity assessment of a medical doctor. In a 2020 decision, Kate's estate, the court adopted the reasoning in K that the evidence of the drafting solicitor who had met with and spoken more often to the testator should be preferred over all else, even that of medical professionals. In Deschmet and Cheshire, a 2023 will challenge decision of Justice Gilmore, Her Honor looked to the drafting lawyer for support of testamentary capacity. Her Honor found that the drafting solicitor's notes were minimal, unhelpful, and unreliable, and the lawyer's evidence 3 years later was based only on memory. The lawyer did not have an understanding of the seriousness of the testator's medical conditions, as no queries were made. The evidence in the medical records could not be ignored and was preferred over the lawyer's evidence. The court concluded that the testator was not of sound mind, memory, or understanding when the will was signed. The decision relies on a varying long list of examples in the medical records of severe cognitive impairment that progressed over a period of time. The testator suffered from severe progressive vascular dementia for 4 years prior. The medical notes describe the testator as being delusional and subject to paranoid thoughts, among others. In support of lack of capacity, Justice Gilmore also noted the testator gave different instructions within a few days. For example, the original instructions sought to exclude his common law spouse of 34 years and leave all to the son. At the signing meeting with the lawyer, he then left the estate to both his son and his common law spouse equally. An hour after signing the will, he expressed regret and wanted to give all to his son again. There was a marked departure from the original will, leaving all to the common law spouse, and now only leaving half. Neither the lawyer nor the testator spotted the wrong last name for the son in the will and the powers of attorney. The asset information was incorrect. The testator stated he lived in Barrie when he lived in the condo in Toronto. The lawyer testified that the testator read the will to himself before signing, when we learned later that he was no longer able to read at the time. Justice Gilmore did not find, though, undue influence, and that the testator was not coerced by the son to the point where the father no longer exercised free will. And the decision gives more explanation as to why she did not find undue influence. Now let's look to the red flags. The list of red flags could be endless, which just makes our job even harder and concerning to avoid a will challenge. So I outline only main ones and divide the list into 2 categories. These should be considered in the context of the test for testamentary capacity. So red flags for lack of testamentary capacity. For example, a testator has difficulty with simple tasks, such as producing identification or paying an invoice, difficulty in taking directions, difficulty or inability to recall prior discussions and instructions, provides inconsistent instructions, which is more than just indecisiveness, doesn't remember instructions given, information was provided by family members and the client cannot confirm or remember, inability to recall whether a prior will was done and the contents of the will, inability to provide a general understanding of assets and current values. As mentioned earlier, the expectation is not to know assets to the penny, but it would be concerning when the values are irrational, such as stating a value of a Toronto home being $300,000. Cannot provide details of family dynamics and those who expect to inherit. There's irrational explanations for why certain family members are excluded and others are favored. The instructions generally do not make testamentary sense. There are notable changes in the testator's behavior, either mental or physical health before, during the time that the will was prepared, and reattendance for executing the will. Now let's look at red flags for undue influence or suspicious circumstances. The age or sophistication of the testator that would make him more vulnerable or susceptible to undue influence should be considered, whether it's a dominating spouse in a joint retainer. The testator is socially isolated for some time. The testator experienced recent family conflict or alienated from family members. The testator experienced recent bereavement, making them vulnerable. Got into a hasty marriage or living arrangement with a beneficiary of a proposed will, ability of the beneficiary to coerce or control the testator. There's reliance or dependence on the beneficiary for emotional and physical needs. The beneficiary is involved in all aspects of the will creation, from contacting the drafting lawyer, making an appointment, accompanying the testator to the meeting, and trying to take part, or does most of the talking on behalf of the testator. The beneficiary is a person who the testator had a relationship with, but that person is not known to the family. Most information about the testator, such as medical status and cognition, come from the beneficiary. Suspicions that the instructions are not those of the client. For example, a client attends meetings or phone calls reading from a script or prepared instructions of someone else. Testator's reasons for drastic changes from prior wills in terms of beneficiaries and share of estates are unreasonable, irrational, or suspect. Or the testator's failure to provide a reasonable explanation for choices of beneficiaries. It could be inducements held up by the beneficiary of the testator, like if you give me this, I'll provide support or I'll take care of you. Evidence of acts of physical or mental cruelty, either by or against the testator. Substantial pre-death transfers of wealth from the testator to the beneficiary. The lawyer was chosen by the beneficiary and unknown to the testator. The beneficiary prepared a draft of the will or received the draft of the will for review before execution. And the documented statements, there could be documented statements from the testator that was afraid of the beneficiary. So these red flags should be considered, again, in the context of how they affect the client and how it affects the will being drafted or prepared. For example, I have an Italian-speaking clientele made up of older Italian immigrants who rely on their Canadian-born children to translate for them or interpret documents for them. So there is a language barrier when relying on documents in English for these clients. So normally being selected and called by the adult child who stands to benefit, who asks about a will for an Italian parent, and maybe who fills out the questionnaire, are, as I mentioned above, red flags for undue influence. But they can be explained where there was a language barrier and cultural expectations on the adult children. Before being retained, I limit any communication with the adult child to avoid tainting my file. I confirm I can speak Italian and have the parent call me directly and direct the child to never communicate with me again. I do not engage in discussions with him or her about the will to be prepared. I expect also to receive the completed client identification form and questionnaire to be in another's writing because of the language barrier. Having Italian immigrant parents myself, I can spot the different calligraphy from what I expect my older Italian client. Most importantly, confirm all information with the testator independently twice. So what do we do if we're concerned that your client lacks capacity? Should we turn to a doctor's report or capacity assessment? So to start off, the further discussions, you should have further discussions with the client, and investigations are warranted to determine the root cause of the capacity concern. If cognition or caused by something unrelated to capacity, such as hearing problem, vision problem, language barrier, or medications. It remains a drafting lawyer's responsibility to assess capacity based on the legal test. The drafting lawyer's assessment remains the opinion most relevant to whether the client has testamentary capacity and carries the most weight, as we see in the decisions on will challenges. However, the drafting lawyer can seek other information to support the opinion of capacity or to remedy a concern of incapacity, such as the opinion of the client's doctor or capacity assessor. It is a factor in support of, rather than in place of, the lawyer's opinion that the client has testamentary capacity to support the validity of the will being done. But doctors and some capacity assessors are usually not aware of the legal test or trained to give an opinion on testamentary capacity. I have seen doctors' opinions in will challenges simply state, patient is able to make a will. It does not elaborate on how or why or address the factors of the test for testamentary capacity. The other concerns are the timing of the assessment relative to what instructions were given or will to be signed, and the extent of information available to the doctor or assessor when formulating their opinion. If going to seek such an opinion, best to provide clear instructions, the capacity being sought, and the legal test to apply. My practice is not to seek or rely on the client's doctor's opinion or capacity assessor's proof of testamentary capacity. Instead, I ask for medical information the doctor is qualified to provide. A list of, for example, a list of medications and diagnoses, and whether the medications affect cognition, ability to process information, or make the client vulnerable. Requesting a capacity assessment or doctor's opinion creates awkwardness with the client as you are questioning his or her capacity. It could be explained to a client that obtaining the assessment strengthens the validity of the will being prepared, assuming it comes back positive. Requiring capacity assessment must be reasonable in the circumstances. A lawyer should be careful to ensure that the third-party assessment is actually required to complete the retainer, because a finding of incapacity could result in significant loss of independence, and particularly the inability to have a will done. When deciding between a doctor's opinion or capacity assessor to assist in determining capacity, consider also the cost of a formal capacity assessment, which can be quite high, and the testator must formally agree to be assessed to proceed. Thank you for listening, and happy International Women's Day to everyone who celebrate tomorrow.
Perfect. Thank you so much, Sandra. We will be holding questions to the end, but we did get a lot of questions about the citations that Sandra was citing. So we will do a follow-up and send it out to you probably in the survey regarding the program. So that will come in the future. Okay, we will turn it now over to Karen.
Thank you. So I'm going to be talking about issues relating to minors and dependents, both in the estate administration context and in the estate planning context. So I'll start by talking about estate planning. I'll go over some common misconceptions from estate planning clients, and then I'll discuss trusts for minor and not so minor children, and considerations when dealing with estate assets versus non-estate assets. Finally, I'll talk about the consideration of dependents when you're doing estate planning. And then this consideration of dependents is also relevant when advising estate administration clients. So we'll go over how to advise your estate trustee clients when there's a potential dependent support claim. Then I'll spend some time talking about minor beneficiaries, how the presence of minor beneficiaries will affect the administration of the estate, and when the Office of the Children's Lawyer needs to be involved. So let's start by just talking about some fairly common misconceptions that tend to come up when meeting with estate planning clients. And one of those is that a child's parent or guardian is automatically also the guardian of property for that child. And I have found that this misconception is not just held by clients who are not lawyers, but also by other lawyers who maybe don't practice in this area. So, for example, people will often not realize that when they designate their child as a beneficiary on a life insurance policy or a TFSA, that unless they also designate that child's other parent as a trustee, that money will not be paid out to that family member, but rather will be paid to the accountant of the Superior Court of Justice. Another thing that many people assume is that if they designate someone to be the legal guardian of their child in the event of their deaths, that those same people will automatically be in charge of their child's money. And I find this one interesting because once I flag the distinction and go over the difference, it actually sometimes puts people at ease, and it can obviously impact who they choose as the person they would like to be their child's caregiver in the event of their death. This brings us to another misconception, which I have found, which is that the designation of a guardian of a child in a will is binding. I find that most of my clients who have young children are very surprised to learn that this is not the case. Section 61 of the Children's Law Reform Act deals with testamentary decision-making and guardianship, and it stipulates that the appointment in a will is valid for 90 days. And after that, the guardian will have to bring an application to the court. And so I find that most people are absolutely fine with having the cost of that application paid from the estate. And I usually include something to that effect in the paragraph that deals with the designation of the guardian. So because of the confusion that I often encounter about the above misconceptions, when a client has minor children and wants to deal with both the guardianship of their child, like of the person, and also are dealing with their assets, I like to start by very big picture, in very plain terms, going over the distinctions between the roles of a guardian with respect to decision making, so what used to be called custody, an estate trustee, and a trustee of the child's funds. So I like to make sure that they realize that that trustee can be someone distinct from the estate trustee, who they can designate to hold the child's funds in the context of the will, just as they can also designate a different or same trustee for any registered asset. So most people do not want their children to have access to all of the money left to them at age 18. And so when discussing a plan with a client, it's important to consider any insurance policies or registered accounts. Unless there is a term in the designation that specifies a different age or allows you to specify a different age, a minor who is the designated beneficiary on an insurance policy or a registered account, such as a TFSA or RRSP, will receive those funds once they turn 18. If there is a trustee designated to hold the funds, legally they must pay the money to the child when they turn 18. Now, often people will enter a name in the designated beneficiary section, but they do not fill out the trustee section. And if the beneficiary is a minor and there is no trustee designated, then the funds are paid to the accountant of the Superior Court of Justice, and the accountant of the Superior Court of Justice pays the funds out when the child turns 18. With assets covered by the will, there's a lot more flexibility in when and how a child gets their entitlement. So often that is a consideration in how to divide the estate assets versus the assets that fall outside the estate. For example, if a client has an adult child or children from a previous relationship, and then they have a minor child from a newer relationship, your client might want to designate the adult children as beneficiaries on the assets that fall outside the estate and leave estate assets to the minor children so that they can prevent them from getting their funds at 18. I also find that many parents want their kids to get their money when they're much older, often 25 or even 30. So you also want to make sure to avoid a Saunders and Vautier situation where the child can turn around and ask for their money at 18, despite the will saying that it should be held until they're, say, 30. So I generally explain to the client that we should include a gift over in the trust provision for the child, and I explain why. And for those of you who need a little reminder about Saunders and Vautier, that was the case that basically allows the beneficiaries to ignore the testator's or settlor's intentions and vary the terms of the trust. And obviously, that's not desirable if what your client is trying to do is make sure that the money isn't accessible to their child until they're older. When doing estate planning, especially for someone who might have a previous family and maybe a new common law partner, having a discussion about the potential for a dependence relief claim is important when figuring out how the person's assets are going to be divided. And we heard about this a little bit earlier as well, especially if when you're doing your initial meeting with your client, and if there are a lot of factors that could support a potential claim, that's something that you're going to want to discuss with them. So I tend to ask about every relationship, every child, and also any children that may not be biological children, but children with whom they may be living and providing support. I also like to get copies of separation agreements in order to determine what support obligations they may have. And the client may not think it's important to mention people that they don't want to include in their will, but it is so important to get all of the branches of that family tree. Understanding that family tree is no less important when advising an estate trustee in the context of an estate administration. So some important things with respect to advise your estate trustee client with respect to dependence relief. First of all, the limitation period. So a dependence relief claim must be commenced within 6 months of the issuance of the certificate of appointment. However, Section 61(2) of the Succession Law Reform Act does say that the court may allow an application to be made at any time as to any portion of the estate remaining undistributed at the date of the application. So if an estate trustee is put on notice and distributes before this time, the 6 months, then the estate trustee can be held personally liable. and that's in section 67.3 of the Succession Law Reform Act. Another important thing to advise your estate trustee client is that section 72 of the Succession Law Reform Act allows for assets that would pass outside of the estate to be clawed back into the estate for the purpose of a dependents relief claim. This includes money in joint accounts, in accounts held in trust, life insurance money, and money in registered accounts for which there was a beneficiary designation. Again, if the estate trustee is put on notice that there will be a dependents relief claim, you want to advise them not to distribute any of these assets. So when you're having your initial meeting and finding out about the family, and if the estate trustee is aware that there was a common law partner who's maybe not in the will, then you want to just let them know that if a claim is brought, distribution of the estate is stayed. And again, you want to emphasize that they can be held personally liable if they continue to distribute the estate after they're put on notice. And of course, if the deceased left behind a child, and if that child is not adequately provided for by the will or through the intestacy laws, there may be a dependents relief claim brought on behalf of the child. So in dealing with children or minors in the estate administration context, it's worth going over the circumstances under which the office of the children's lawyer needs to be served or might get involved. So first of all, when you're applying for the certificate of appointment of estate trustee, if there are any minor beneficiaries, even if they are contingent beneficiaries, the office of the children's lawyer must be served. It's not sufficient to serve the parent or guardian of the minor. And if you don't serve the office of the children's lawyer from the beginning, it can potentially make things more difficult later on. And it's also worth noting that when you serve them, you need to provide them with a copy of the complete will, if there is one, and any codicils. It's not sufficient to just send them the page that mentions the entitlement of the minors. And again, I mention this because if you don't send them the complete will from the get-go, it will just end up causing delay because there will be back and forth and you're going to end up sending it to them anyway. So depending on the nature of the entitlements of any minor beneficiaries, you may or may not need to provide the children's lawyer with further information, such as draft estate accounts, etc. So in a situation where you are only retained to get the certificate of appointment, in your reporting letter to your client, you want to make sure to let them know what they need to provide to the Office of the Children's Lawyer with respect to estate accounting or confirmation that funds have been put into trust for any minor beneficiaries. And I actually find it helpful to flag this information for the client, outside of the reporting letter as well, because I find that they don't necessarily read everything. So sometimes accompanying the application for certificate, you require consents of the beneficiaries. Now, this often comes up in intestate estates or in estates where the person applying to be estate trustee was not named in the will. And this is often accompanied by a situation where your client is applying to have the bond requirement waived. Now, in most such circumstances, if there is a minor beneficiary, the court will accept a consent signed by the minor's parent or guardian. However, in a situation where the proposed estate trustee is also the parent or guardian of a minor beneficiary, that is a potential conflict to have that person also sign the consent on behalf of the minor. Now, in order to address this, you can, in the affidavit that you prepare for your client for dispensing with the bond, include an acknowledgement of the potential conflict and an explanation of why the parent is still the most appropriate person to sign the consent on behalf of the minor. Now, the court could come back and say that they require you to serve the children's lawyer or that they require the consent of the children's lawyer. In general, the children's lawyer does not take a position on matters such as dispensing with a bond or on the proposed appointment of an estate trustee, since it usually has no knowledge of the estate at this point. So often it is sufficient to serve them along with the endorsement and then to file their response with the court. Similarly, if you're retained to help with the estate administration right until the end, your client may want releases from the parties before making final distributions. Now, your client has two options. They can either secure releases from the beneficiaries or pass their accounts with the court. Now, if any of the beneficiaries are minors, minors cannot provide a release. The office of the children's lawyer will also not provide a release. So the only option, if your client wants that certainty, would be to pass the accounts of the estate. And you would want to have that discussion with them about the cost of doing that and whether it's worth doing so in the context of that estate. Then if you do go that way, the notice of application to pass accounts would need to be served on all the beneficiaries and on the office of the children's lawyer if there are minor beneficiaries. When your client is ready to distribute, again, as most people do not know that parents or guardians of a child are not guardians of that child's property, it needs to be made crystal clear to the estate trustee that the children's shares cannot be paid to the parents of those children unless the will actually names the child's parent as trustee of the funds, or unless the child's entitlement is $35,000 or less. And that's in Section 51 of the Children's Law Reform Act. That amount used to be 10,000, but I think it was about 4 or 5 years back, they upped it to 35,000. So if you are advising an estate trustee in the case of an intestacy, because there is no will and so no trust provision, any money going to a minor beneficiary, if it is over $35,000, needs to be paid to the accountant of the Superior Court of Justice. And you can either help your client with that process, but the instructions for doing that are pretty straightforward and can be found on their website. The only alternative to paying the funds to the accountant of the Superior Court of Justice is if the parent applies to be guardian of property. But that is it's not a straightforward process. For estates that end up being contentious, so where there's litigation, such as a will challenge or a dependent support claim, and where there's a minor beneficiary or a minor dependent, in that case, the children's lawyer needs to be served. And this is because of Rule 7.032, which says that where a proceeding is against a minor in respect of the minor's interest in an estate or trust, the children's lawyer shall act as the litigation guardian of the minor respondent unless the court orders otherwise. Another instance, which not everyone is aware of, is that the children's lawyer may need to be involved if there are minor beneficiaries and there's real property in the estate that is being sold. So it could be, again, that the deceased died intestate, or it could be that there is no power to sell the real property under the will. And in this case, if the property is being sold for the purpose of distribution to the beneficiaries, and some of those beneficiaries are minors, you'll require the children's lawyer's approval. And if this is something that you inadvertently forget, it can cause problems, especially if your estate trustee client has already taken steps to sell the property. Now, the children's lawyer approval is not required if the property is being sold to pay debts of the deceased that existed at the time of death. The other situation involving real property where you'll want to contact the office of the children's lawyer is if the estate trustee is considering purchasing the estate real property. So if you're helping your client with the administration, and if there are assets that pass outside of the estate, such as life insurance or proceeds from registered accounts, just make sure that they're aware that those funds will be paid into court if there are minor beneficiaries. And your estate trustee client or the parents of the minor beneficiaries might have questions with respect to what happens to the money, etc. And when the money is paid to the accountant of the Superior Court of Justice, you can let them know that the parent of the minor will receive an information packet with everything they need to know in terms of how the money is going to be invested and when the money will be paid out. Finally, for a lot of these matters that come up in the estate administration context, with respect, especially with respect to who needs to be served, a lot of the answers can be found in the rules of civil procedure. So it's always worth looking there as a first step, if you're not sure. And that's it. I hope you've found this helpful. Thank you.
Thank you, Karen. All right, amazing. We usually we go over time, but we finished a few minutes early, so we have some time for questions and answers. We got a lot of questions, so I will pick out a few, and hopefully we can have our speakers answer some of them. I want to start with saying, if you've been asked, and this is not a question that came in, but just in general, if you've been asked to provide your file to another lawyer or court, we encourage you to report it to LAWPRO before you provide the files and notes, and that way we can help you walk through it. So that's you file a notice of claim. There was a lot of questions on, do we have a checklist at LAWPRO? To the best of my knowledge, we don't have a checklist, but it's something that, of course, we can work on. Panelists, if you have any checklists that you're willing to share, please send it to me. You can always post it. And I do think there are some good material out there. The LSO might have material too, so we will look into that. Okay, questions coming in from attendees. Sandra, I will pose this to you. The question was, I think there were similar questions like this. How should one deal with an elderly client who insists on having a child accompany her at the initial interview with the lawyer? Other similar questions were, to what extent can we allow a child to act as an interpreter if the client does not speak English well, or is having trouble communicating?
Okay. I did see those questions at the box. So basically, my first thought would be, to what extent does that parent want to have that child in that meeting? Is it just to accompany to the office and then you meet with them in person? I want to know why they want that child to be there, and whether that child is supposed to benefit in an unusual way and somehow kind of controlling the parent. That's a concern I would have. But at a certain point, though, you can just say, no, I don't want your child to be here. If it's a question of language barrier, then you should really be asking yourself whether you should be taken on that file. In my presentation, I talked about Italian-speaking clients. I feel comfortable. I'm speaking Italian. I know I can communicate. If it's someone who speaks another language that I don't, it's not right. It's not fair to the client to do that, in my opinion, and I don't take that retainer. And bottom line, if you don't feel comfortable that that child's there, I just won't accept the retainer, or I have to figure out first why. Sorry, are you hearing me? Why that child has to be there.
Perfect. Thank you, Sandra. Chris, I'm going to pose this question to you. There's some similar questions that come in about, how should one deal with the issue of clients being reluctant to provide detailed information about their assets? If they, do we have an obligation to investigate the assets individually, or can we rely on the information the clients have provided?
Sure. We do have an obligation to conduct some investigations into the assets, like I said, because sometimes clients are just going to misunderstand how they own assets, and because the advice that you're going to provide to the client about the estate plan is going to differ depending on how those assets are held, right? If they're going to pass outside of the estate, or there's beneficiary designations, that's going to completely potentially upend what the client wants to do in the will. If there's shares or assets that are potentially non-probatable, then perhaps dual will strategies should be recommended to the client. So without conducting that thorough investigation and getting all that information from the client, you're not going to be able to provide them with the full range of options that you should be able to provide them with. Now, look, if the client is reluctant to provide the information, there's no perfect solution, but the first thing we need to do is to document the client's reluctance and document your advice to the client, probably at multiple points throughout the retainer in a reporting letter saying, look, I advised you that you need to provide me all of this information so that I can inform you of all of your options. You've advised, you've decided that you're not providing this information. This limits the kind of options and advice I can provide to you, and probably confirm that again at the end of the retainer. Is it a perfect, will that be a perfect defense in every situation? No, it won't, but it certainly will help. Right. So I think you just need to paper that file sort of up and down about the advice that you provided and the client's reluctance to provide the information.
Perfect. Thank you, Chris. Tamar, maybe you can answer this question. What are your thoughts on interviewing clients and taking instructions on Zoom? There's no personal contact. You don't know what's happening in the room. How do you handle that?
Yeah, so I don't know who submitted that question, but is the second part of it, like, would you also not be with them for the signing, or is it just that the initial call is on Zoom?
Yeah, let's go with the
first
scenario, and you don't ever meet them in person.
That would make me uncomfortable. It does happen, especially when clients are in older age homes, or if they're international. Sometimes I might not meet them face to face. I think that as a first step, you should always be asking them to turn their camera around so you can see who's in the room. We did have a situation where we were speaking with the client and no one was in the room, but you could hear that behind a door there was somebody saying something to the client. Definitely would meet with that person in person. Yeah, like I'm just trying to think of any situation where I've never, I guess during COVID, we like, especially in the first year of COVID, we weren't necessarily meeting with clients in person. I would ask way more questions than I normally would, and I would try to be social about it. So, like, have you gone on vacation? Tell me about your family, your friends. And it would come off very natural, but really it would be to get a sense of their capacity and whether they were being influenced by anybody. And then again, with the signing meeting, I would probably ask even more questions than who's in the room. Like, where are you? Okay, like, you're at home. Like, is anyone else home with you right now? Is anyone else on this call? Although you should be able to see it if it's on Zoom. Yeah, I would do the best I could and just make notes of everything, because at the end of the day, that's all you can do.
Thanks, Tamar. To all of our panelists, are you finding that you're meeting people in person now, or you're still doing a lot of remote work?
We generally meet people virtually until the will signing. And then for the will signing, we'll meet them in person.
Karen,
That's like for me too. Yeah, I won't sign documents by Zoom if I can avoid it.
Yeah, same. I usually do my first chat with them by video, and then we have phone calls back and forth, and then it's always in person for signing the will.
I also try to use emails. If I'm asking follow-up questions, I like to document them by emails. If your client uses emails, my elderly Italian clients don't. Everything by mail or detailed phone conversations with detailed notes.
Okay, another question, and Karen, maybe you can answer this one. To what degree does an executor have to investigate unknown beneficiaries? Meaning, if a child provides for distribution to my children without naming them, what kind of searches are required to determine if there were additional children unknown to the family before distributing the estate proceeds?
So is this, okay, so I'm wondering, is this question getting at possible, like, children that would be unknown to any members of the family?
Yeah, like, let's just say, the deceased passed away, didn't have that many close family and friends, left it to my children. say hypothetically, the children also think dad or mom had other children, what is the obligation?
So I think this would be very like a fact specific thing. Like I think it would be about looking at, obviously talking not only to talking to the estate trustee who is really, on the hook for finding out all of this. And so I think it would be about having a conversation with him about like the other family members, any other family members, um, finding out any information potentially. And I guess also, in that situation, if there is someone out there, making sure that like that sort of that if someone finds out about the death and if they're a potential long lost child, then we've certainly found that they'll come out of the woodwork. So, but again, I think this is very fact specific, and it would be very much about like depending on, there's always some family member who's going to know something, I think.
Mhm.
And so it would be about having those conversations. And, if the estate trustee isn't well placed to find that information out, then making sure that the estate trustee talks to the family members that are.
Did you also mean that in terms of drafting when the testator is with you and says they've all to my children, the question of how much to investigate who the children are at that point?
I think this
Oh,
question was about estate administration, but
Oh, okay, my bad. I had a situation where the person died intestate and he had children in different countries. Some of them were adopted out, some of them were taken by CAS. Trying to figure out who the children were was a disaster. Disaster.
Yeah,
Just,
I can imagine, and we've certainly seen some claims with the term "my children" or "my issue," because that can lead to all sorts of unintended consequences, right?
Mhm.
So if you can specify who the beneficiaries are, I think that's preferable. If not, then advising the client that this can include children of your children outside of their primary relationship, right? People that you don't even know exist. Uh, because again, sometimes there are these surprises on the estate administration, and sometimes that can cause some problems.
I prefer to name the children in the will.
Yeah,
Just tell me who you
I
think
think
the
that's that
children are, and that gives me an idea of who the testator thought their children are, and just
exactly.
they know who they're trying to benefit.
So I think it depends, like on the drafting side, I think for us, it really depends on what the age or ages are of your client. A lot of the time we'll say like child or issue by reason of relationship of parent and child set out in part 1 of the Children's Law Reform Act, and then we'll specify whether posthumously conceived are excluded, and whether any other children are excluded, because if you have a client who's 30, they're probably not going to come back to you for a long time. And they might have more kids. So we would not name the kids or grandchildren in that situation.
Thank you. I think we have time for one more question, and I'm just going to open it up. There's variations of this question. So what is a lawyer's obligation when they acted for spouses in drafting wills? They're holding the original will, and then later one spouse comes back and wants to either destroy the will or change the will. Another similar question is, I prepared a will for a married couple. They later separated, and then the separated spouse, one of them wants me to change it. Do I need to get consent from the other spouse? And another similar question is second marriages and adult children. So existing clients who previously had mirrored wills, everything to each other, and then leaving 50-50 between their respective children from previous unions. And so after the first spouse dies, the second spouse comes and requests that they change their will, leaving everything 100% to their children alone. So now they have inherited everything from their spouse and they're leaving everything to their children. So loaded questions, but if any of you want to speak to any of those questions kind of generally and how you handle those. Don't go at once.
So I actually have it set out, like when I have a couple come to me to do wills, it's actually set out in the retainer agreement that, I let them know right off the bat that if they're doing their wills together, this is a joint retainer. And if in the future one of them comes to me, I either have to decline or I have to get the consent of their partner. So I kind of make that clear to them right off the bat.
I think those are the general joint retainer rules under the practice, under the
Yeah.
rules of practice.
Practice management guidelines, and the commentary there under 3.45 is quite helpful because it addresses some of these situations. And a lot of them are going to be pretty fact specific, right? Like those questions, it's going to depend on a lot of variables, probably how to navigate through it. But the guidance in the commentary in the rules is quite helpful.
Yeah, and I unfortunately had too much litigation background to look at this and think, could this end all happily? Probably not. And so I say no, thank you. There's like 100 lawyers after me who can help you. Please go ahead.
There. All right, I think we're at time. We are at time. So a few things to wrap up. This program is eligible for 1.5 professionalism hours and for LawPro's risk management credit, which can be claimed at lawpro.ca. The program will be available for replay on practicepro.ca's CPD's webpage. When this is available for replay, we will send out a post via avoidaclaim.com blog. If you want to be in the know, subscribe to it, and you'll get regular updates on risk practice management tips and fraud prevention. There is a link in the chat for a survey. Please complete it. It will help both TLA and LawPro understand and know what information you want to hear about. And so we could develop timely programs. You will also receive an email for program evaluation. And if you have any comments, suggestions, you can always write to us as practicepro@lawpro.ca. LawPro is also on social media. So on LinkedIn, it's more substantive content. And then we have an Instagram account with short, fun posts. We also have a Facebook account. And I want to say Twitter, but it's called X, on an X account. I want to thank everyone at Toronto Lawyers Association and the staff at LawPro for making this run so smoothly. Thank you for everyone who promoted it, and thank you so much to our speakers for sharing their time and expertise. Thank you so much. This concludes our program. Please take care and join us again in the future.
Thank you.
Bye, everyone.
Bye.
Thank you. Bye.